There was a big Supreme Court argument today that could fundamentally change gun laws in states around the country. The court heard arguments in a case brought by New York gun owners challenging century-old restrictions on carrying concealed handguns in public, basically taking on a law that requires gun owners to show what's called proper cause or a special need to carry a handgun in public for self-defense. Now, they say it violates the Second Amendment to the United States Constitution. But first, let's take a quick step back. There was a landmark opinion in 2008 known as the Heller opinion. The 5-4 decision, for the first time in legal history, established that the Second Amendment protects an individual's right to own a weapon. Today, the question is, how hard can a state make it to carry a concealed weapon for self-defense in public? First, Paul Clement, arguing against that New York law, said his clients should have a constitutional right to carry handguns in New York City without providing that proper cause.
The text of the Second Amendment enshrines a right not just to keep arms, but to bear them. And the relevant history and tradition, exhaustively surveyed by this court in the Heller decision, confirm that the text protects an individual right to carry firearms outside the home for purposes of self-defense. Indeed, that history is so clear that New York no longer contests that carrying a handgun outside of the home for purposes of self-defense is constitutionally protected activity. But that concession dooms New York's law, which makes it a crime for a typical law-abiding New Yorker to exercise that constitutional right.
Now, meanwhile, New York Solicitor General argued that New York has a right to make their own rules, saying in part, New York is not an outlier in the extent to which the state restricts the ability to carry firearms in public, and it's not an outlier in asking a licensed applicant to show good cause for a carry license. Now, based on the justices' questions, they sure seem ready to strike down this New York law. So if that happens, what does that mean legally? Joining us now is Darrell Miller, professor at Duke University Center for Firearms Law. Thank you very much for coming on the show. Appreciate it. So is it fair to say that depending on the ruling here, that this case could erase most of the toughest gun control laws in the country?
Oh, absolutely. I think that's fair to say. If the court strikes down New York's law, it imperils similar laws that are in states like Massachusetts and New Jersey and Maryland and California, for example, states that cover about 80 million people or about a quarter of the population. And I think it would be fair to say that if the court rules that you have a Second Amendment right to carry a firearm simply on a desire to do so for self-defense, that you'll see more guns in more places in America.
Now, you know, there's a lot of debate occasionally about whether there should be what's called assault weapon legislation. Comes up, goes away. It existed for a while. Will the ruling here have any impact on that kind of legislation?
Not directly. That is, this particular case is more about whether you can carry a firearm with you concealed on your person. The question you're asking has to do with a second kind of question, which is what kind of weapons are protected by the term arms in the Second Amendment. And there are cases that are percolating in lower courts right now that the court might end up granting cert on to hear in a future case. But this particular decision doesn't go to that issue about things like large capacity magazines or assault rifles.
I want to play another piece of sound from the oral argument today. It seemed that many justices were concerned about the issue of public safety. I want to play an exchange with Justice Stephen Breyer.
The difference, of course, you have a concealed weapon to go hunting. You're out with an intent to shoot, say, a deer or a rabbit, which has its problems. But here, when you have a self-defense just for whatever you want to carry a concealed weapon, you go shooting it around and somebody gets killed.
With respect, Justice Breyer, that's not been the experience in the 43 jurisdictions that allow their citizens to have the same rights that my clients are looking for.
You know, one of the things, Professor, that's always struck me is that there's always this talk about hunting in connection with the Second Amendment. And yet, the whole reason that that 2008 Heller decision came down is based on what the framers had intended back when they created the Second Amendment to the United States Constitution. And when they created and wrote the Second Amendment, regardless of what you think it should or shouldn't say, it wasn't to apply to hunting. And so I wonder why in these debates there's so much talk always about hunting as opposed to what the framers had intended, which was to protect the citizens at times against its own government.
Well, I mean, there's a lot packed in that question. So, and a lot of assumptions. So, yes, you're right. The court says there's a right to have an arm in your home for personal purposes or individual purposes that are lawful, including self-defense. And that including is doing a lot of work, which might be one of the reasons why we keep talking about hunting and other kinds of recreational uses of firearms. Your latter point is one that is a point of quite a bit of contention about what exactly does the Second Amendment protect? Is it about individual self-defense? Is it really about defending ourselves from a tyrannical government? Those are the kinds of really deep philosophical questions that the court has so far not really engaged in and might have to in the future. Right now, they're solely focused on the issue of self-defense as opposed to these other reasons we might have the Second Amendment.
All right, so finally, based on what you heard today, what would be your prediction as to what the court's going to do here?
Well, predictions are a mug's game, and you never know. The Obamacare sounded like it was going to go a certain way and went another way, for example. My prediction at this point is the law looks like it's going to go down, and then the question really is, how broadly will the majority write the opinion, and what kind of tools will they use to say that it is unconstitutional? Will they say it's too much discretion? Will they say there's not a law like this in 1791 and therefore it's unconstitutional? Those are the big questions that I'm going to be looking for.
Yeah, but I do think that the betting, and I know that professors don't like to do the betting stuff, the media people love to do it, so that puts us at odds right there. But in terms of the betting, based on the fact that the court took the case, based on the types of questions we heard, based on the types of justices that there are, I think the expectation is that this law will be struck down. And as you point out, the question then will be, okay, how broad is it in terms of what they're saying and what kinds of laws can exist moving forward? But to be clear, this wouldn't mean that people can't have gun control laws at all.
No, not at all.
Right.
Heller itself still has limits. It's just going to put a lot of pressure on governments that want to regulate firearms in these other ways that they can say, for example, schools can bar weapons. It's going to put a lot more pressure on those other areas as opposed to a licensing scheme.
Right. Professor Darrell Miller, thank you so much for coming on the show. Really appreciate it.
It's been my pleasure. Thank you.
Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.